Retaliation. Retaliation in all of its forms. You have heard, I am sure, many times, that Ohio is an employment at will state. That means I can quit any time for any reason. I can be fired at any time for any reason. Which is true. There is a doctrine called employment at will. Whoa, here we go. Trying not to turn my head, Jim. I know I need a can of spray here. That is the main doctrine. What we're talking about here is you have to have an employment relationship. Independent contractors really is not going to apply to our presentation. So there is the employment at will doctrine, except, and the exceptions swallow up the rule. And what we're going to talk to you about today is treating employees in the workers' comp world and outside of the workers' comp world in a retaliation fashion. Public policy is one exception to the employment at will doctrine. It's sort of a broad policy. It can apply in numerous circumstances, an unlimited amount of circumstances. But at least we know in Ohio we have basic elements. You must have clarity. It must be a very clear public policy. And this public policy can be found in Constitution, in administrative rules, in legislation, even in common law. Common law is just court cases that we have. So that's where the public policy can be found. Then there's the jeopardy element. So is this situation being put into jeopardy? Is this public policy that is found in the Constitution and rules, legislation of the Constitution, is it being put in jeopardy by actions of the employer? Now those two elements are judicial. A judge decides whether those elements have been satisfied or not. A plaintiff then will argue that those elements have been violated because I was dismissed in violation of those elements. Some retaliation was taken against me. And then the other element is really a question. Is there an overriding legitimate business purpose for the termination or retaliatory act of some sort? The causation and overriding justification elements are determined by a jury. So that's the public policy exception. We see it regularly in employment actions, regularly. Okay, well, we almost got the cart before the horse. Let's talk about what is retaliation. It's discrimination against someone for opposing an unlawful action. That's called the opposition clause. That means I don't like the way this supervisor is treating a person based upon a protected class. And I'm opposing it in the workplace. I'm vocalizing against it. That's the opposition. There is also what we call the participation. So your employees can participate in activities. They can participate testifying in a lawsuit that involves discrimination, even going to an OSHA situation. They can be protected just for participating. But we'll get into it a little bit more later, maybe. Now, why are we talking to you about this? Because it also is involved with Greg's part of the presentation in workers' comp. Retaliation is the most often filed action going today anyway in the EEOC, the Equal Employment Opportunity Commission. It's a very real problem. It kind of maybe even flows a little bit for whistleblower protection. You know, I'm going to say OSHA. I called OSHA And that's the way I feel when I have clients whose employees say, I called OSHA and I'm being subjected to discriminatory action. So I'm then protected in a certain sense. Now, it's not a real whistleblower situation where you think I'm giving information to an agency that they're doing something they shouldn't do. You may think that that's more along the lines of the Sarbanes-Oxley Act, but it also applies to the administrative agencies. Well, what do you have to prove? You have to, as I said, you have to have an employment relationship. The employee has to be engaged in some protected activity, as we talked about. The employer subjected the employee to inappropriate adverse employment action, and there's a causal connection. So you have the employee doing something, opposing a discriminatory action or participating in a case. The employer then terminates them, but there has to be a connection somehow. So what's the standard of proof? Well, you have to know that the employee is doing something they're not supposed to be doing in your mind. In other words, they're participating in a protected activity, they're opposing what you're doing. So the employer has to know that. That's the first point. And before I get to what's on the slide, you know, retaliators retaliate, right? I mean, they don't sit around and wait for weeks and months. So usually there's a temporal connection of some sort. The employee participated in testifying on behalf of another employee who they felt was discriminated against, and within a week, 5 days, that employee is terminated. That's what I mean by the temporal relationship. But what is the real standard of proof? What if you had other reasons, which you always do? This is always the employee you should have terminated a long time ago. It always happens. So you have multiple reasons to get rid of this person. It just so happens that they were involved with participating in some protected activity, and you terminate them because they stink at their job, they don't show up, they disobey orders, but they also happen to be participating in a protected activity. So what's the standard of proof? The United States Supreme Court addressed this issue about 4 or 5 years ago in this case here. University of Texas Southwestern Medical Center versus Nassar. Now, Nassar is a doctor. He worked at a hospital and he also worked at another facility run by this employer. He, just to not get into the weeds, but he alleged discrimination based on race and religion, and then he also alleged retaliation. So he filed a lawsuit. Eventually worked its way up to the Supreme Court. And the issue on this for retaliation, not discrimination based on a protected class, but retaliation, the issue was whether or not the employer was held liable for terminating Dr. Nassar among a multitude of reasons. Poor attendance, poor job performance. Was it a cause of his termination that he believes he was retaliated against? Or was it just one of many causes? Well, the Supreme Court distinguished because in 1991, Congress amended Title VII of the EEOC, and they addressed the standard of proof under Title VII for the classes, race, religion, age, sex. And they specifically said that it is a motivating factor, one of the causes is good enough for a standard to establish discrimination against the classes. However, retaliation is because of, and the Supreme Court said that's basically but for. but for. So when you're dealing with retaliation cases, it has to be the cause, but for the retaliation, the person wouldn't have been terminated. So the bottom line is on this, that it's a higher standard that the plaintiffs have to prove if they're alleging retaliation. Well, what if the plaintiff is, what if they're participating in an activity and it turns out that the claim is flawed? If they're opposing, what if the case is no good? Well, you have to have good faith if you are opposing the discriminatory activity. So the person, your employee, has to have good faith that what they're doing is correct. If they're participating, it doesn't really matter. If the case is no good, it doesn't matter. Since we're at a workers' comp seminar, we need to talk about workplace safety. And you know, OSHA was very active the last few years. Now, the agency really got involved with retaliation against employees for reporting injuries and otherwise talking about unsafe work environment. So the OSHA Act requires employers to inform employees that they can report injuries, they can report unsafe work activity without fear of retaliation. Prohibits employers from retaliating against their employees. This all has to be in writing. You have to train the people on it. Interestingly, and this is the one that caused so much chatter and concern over the years, is that drug testing, automatic drug testing after an injury, was considered to be a form of retaliation because the drug testing, automatic drug testing, didn't have a basis in whether or not the injury was due to impairment of some sort. So here are the rules. We've been through it before. Those of you who've been to our seminars know that you have to advise the people. They have the right to report injuries free of retaliation, and you have to document the training. This is still on the books. There was a lot of talk that this was going to be removed from the law, but it's still good law as far as I know. The drug testing should be somehow connected to whether or not the injury may have been a result of impairment. I don't know, has anybody taken that on? The safety table over here? That hasn't changed. Yeah. So we're stuck with it. I tell clients to do what they need to do to protect their employees, and if they believe automatic post-accident drug testing is the way to do it, then do it and deal with OSHA if it ever comes up. One thing that we need to know, since we're at a workers' comp seminar, is that workers' comp trumps whatever OSHA, well, that was weird, wasn't it? Trumps OSHA. I can't use that word anymore. Workers' comp overcomes whatever OSHA says, because OSHA specifically indicates in their section of the regulation that if you're doing drug testing pursuant to workers' compensation program, that's fine. We're not going to get involved. And that's my brief intro into non-workers' comp retaliation issues, setting the stage for Greg's presentation on workers' comp retaliation.
Okay, under the Workers' Compensation Act of Ohio, there is a provision, 4123.90. It's been around since, I believe, 79. That section was amended to include the second paragraph. And I'll read it. It's summarized on the screen, but I'll read the pertinent sentence. No employer shall discharge, demote, reassign, or take any punitive action against any employee because the employee filed a claim or instituted, pursued, or testified in any proceedings under the Workers' Compensation Act. We call those 90 actions, we call those workers' comp retaliation actions, but this is a statutory authority protecting employees who utilize the workers' compensation system from suffering some adverse employment consequences for doing so. It's a clear prohibition under the statute, and as you can see, not only filing, but pursuing, instituting, testifying. I'm unaware of any particular case, but suppose you have a co-employee who's asked to go and testify on behalf of another employee at a workers' compensation hearing. Is that protected? By the express language of that statute, it looks like it well may be, that person, the testifying employee. Now, the last sentence of that statute contains two jurisdictional requirements. And if they are not met, an action under point 90 will fail. And the first one says, this action under this section will be forever barred unless it's filed within 180 days immediately following the discharge, demotion, or reassignment, whatever action the employer takes. It goes on to say that the action fails if the employee does not give notice of a claimed violation of this section within 90 days of the date of the discharge. So the employer must be put on notice within 90 days of the discharge that the employee believes there was retaliation under this section and plans on pursuing a claim. So, the first question is, when does the 90-day period begin to run? Is it the actual date of discharge, or is it when the employee learns of the discharge? The statutory language is absolutely clear. It is the date of the discharge. However, there is a case decided by the Ohio Supreme Court, Lawrence versus City of Youngstown, decided a few years back. And that case, city employee for the City of Youngstown, the city suspended them without pay, I think January the 7th. January 9th, the city discharged. Wrote a letter to the employee dated January 9th. Copied a number of departments in the city, copied the Public Employees Union with the letter. And the claimant, employee, terminated employee, claimed that he never received the notice, the letter, until, 6 weeks later. And so that went up to court, and I believe the lower courts dismissed the case because it did not meet the 90-day jurisdictional requirement. He got the notice to the employer, I think 58 days after he received the actual letter of termination. And it's very important to point out that the letter was not sent certified mail, it sent ordinary mail. So if any pearl can be gathered from this case, it's when you notify an employee about a termination, send it certified mail. But anyhow, getting on with the case, the court looked at the facts and basically carved out an exception to the statutory rule. And that exception is quite simple, that the employer has an obligation to give reasonable notice of the discharge. Doesn't say how long is a reasonable time. And if the employer does give a notice within a reasonable time after the discharge, the 90-day period begins from the actual date of discharge. However, the 90-day period begins to run from when the employee learns of the discharge if the employee can show two things: that the employer did not give notice within a reasonable time, and the court didn't say what a reasonable time is, but clearly 58 days in this case was not reasonable. And also the employee must show that the employee could not have learned of the discharge using reasonable means. And if those two items can be shown by the employee, then the 90 days begins when the employee learns. So in order to avoid this problem, and in order to get some certainty and get the 90-day period running, serve the notice of termination in a way that there can be no question that the employee received it within a reasonable time. Whether that's verbal, whether it's certified mail, ordinary mail, you name it, but get it to the employee. Carl talked about the burden of proof, and this is a retaliation case, so it's the same analysis. The burden of proof shifts in this type of litigation. Employee has to establish that he was engaged in a protective activity, i.e. he filed a workers' compensation claim, he pursued a claim, he sought more temporary total disability compensation. The employee also has to show that there was some adverse employment consequence after he had pursued or filed the claim, and also that there was a causal link between the adverse employment action by the employer and the workers' compensation activity. If the employee is able to show those three elements, then the employer is up to bat. And the employer needs to show a legitimate, non-discriminatory reason for the action. Something that has nothing to do with this person's pursuit of a workers' compensation claim. And then finally, as in most pieces of litigation, the plaintiff gets the final word. The plaintiff has the opportunity to prove that the reason given by the employer was merely a pretext for the action. And he proves that by showing there was no basis in fact for the action, and whatever the facts in the particular case tend to show. So it's, again, a shifting burden of proof in this type of an action. Okay, suppose an employer does violate this section, and a court finds retaliation is proper. Basically, the remedy is limited by statute. For discharge, it would be back pay and reinstatement. The court has the equitable power to reinstate the employee. For some other punitive action, whether it's demotion or reassignment, any lost wages that may have resulted from the action. And those damages, those amounts would be offset by any subsequent earnings at other employment, temporary total disability compensation paid in the claim, wage loss, unemployment comp, any other sources of income that the employee received during the period he was not receiving wages. You also get a reasonable attorney fees. Now that phrase can be defined in a number of ways, especially reasonable. But that probably in most of these cases is the thing that probably should catch your attention more than anything. Oftentimes it would surpass the damages and the remedies that the statute gives. And because it's an equitable action, because the court has the power to reinstate, there is no right to a jury trial in a 90 action. It is tried to the court. So, rather important case you need to know. It's been around a few years. The facts in the case, Sutton Tomco Machining. There's the timeline. Mr. Sutton injured his back on April 14 of '08. He went into the president's office, president of Tomco Machining, and said, "I hurt my back." Within an hour, Mr. President said, "You're fired." He gave no reason for the termination, other than he said it was not for poor work performance, it was not for his work ethic, and he also said it was not for any violation of work rules. So why he would have said that is beyond me, but he probably didn't know about 90. And so Mr. Sutton leaves the office and leaves his employment. He had not filed a claim. He had not talked about filing a claim. He had not done anything mentioning workers' compensation at the time he was discharged, an hour after he reported he hurt his back. And he complied fully with the 90-day requirement and the 180-day requirement. And so we had a court case. And the employer, having a very brilliant attorney, said there's no action under 90 because he had not filed a claim, he had not pursued a claim, he had not instituted any proceedings under the Workers' Compensation Act, and without him having started, there's no way there could be a violation under 90. And so the complaint that was filed by Mr. Sutton's attorney, also a very good attorney, was 2 counts. Number one, a violation of .90, statute we just talked about, and also a wrongful termination based on public policy, what Carl just talked about. And the Supreme Court held that 90 manifests a clear public policy preventing employers from retaliating against employees who use the workers' compensation system. And the employee in this case is not barred from obtaining a remedy from his employer simply because he had not filed a claim by the time he was discharged. The court agreed that there was no 90 action, fails, 90 doesn't apply, but the tort action applies because of the clear manifestation in 90 of a protected activity, the adverse action taken by the employer, which put that public policy in jeopardy, and therefore that case continues. They only decided those two, the jeopardy and the clarity prong of the public policy action. Went back to trial. Oh, and by the way, it's a tort action, so there is a jury trial. It's not tried by the court, but the positive decision in Tomco was any remedy that a jury may grant the employee is limited to those remedies under 90. And that's it. Be careful when someone is pursuing or filing or talking about filing or has been on compensation for 3.5 years and you're pulling your hair out. Just take a breath, because 90 is there, and it's been there a long time. Thank you.
Thank you.